everyone, we are the Law-vat group and we will be discussing the Section 6 up to the Section 10 of the Ecommerce Act or the Republic Act number 8792. So I am Ruffa Malumay and I will be discussing the Section 6 and the Section 7 of this Act. Under the Section 6 and the Section 7, we have the legal recognition of the electronic data message and the electronic documents. So before that, let us first define what is the electronic data message and the electronic documents. Electronic data message refers to information generated, sent, received, or stored by electronic, optical, or similar means, while the electronic documents refers to the information or other representation of information, data, figures, symbols, or other modes of written expression described or however represented by which a right is established or an obligation extinguished or by which a fact may be proved and affirmed, which is received, recorded, transmitted, stored, processed, or produced electronically. Under the Section 6 and 7, what is protected here is the information. So the information transfers from one medium to another, from a scanned documents to an SMS, from SMS to fax, and from fax to an email. So all of those are now part of the Ecommerce Act or covered by the statute. This legal recognition means that when something is an electronic document and if it satisfies the Ecommerce Act in terms of integrity and reliability, then it is equivalent to a written document. In other words, anywhere in the law that requires that something be in writing, may now be an electronic document. So for example, those that are falling under the statute of frauds, so these are the documents that must be in writing. However, in the electronic document now can satisfy these requirements. In other words, when there is a verbal agreement and that it is not yet performed under the statute of frauds, and that agreement could be documented by the SMS messages or by emails, then it is now be considered that you will satisfy the statute of frauds and that the contract would never be deficient. To sum it up, the Section 6 and 7 indicates that all types of documents that satisfies the functional equivalent as written document shall accept electronic documents as valid documents. That would be all. Thank you.
Good day everyone, I'm Hazel Ann A and I will discuss the RA 8792 Section 8 or the legal recognition of electronic signatures. An electronic signature and an electronic document shall be equivalent to the signature as if in a written document if the signature is an electronic signature and proved by showing that a prescribed procedure not alterable by the parties interested in electronic document existed under 1. A method used to identify the parties sought to be bound and indicate said parties' access to electronic document necessary for his consent or approval through electronic signature. Like for example is party A who is bound for a contract must identify himself and indicate his access whether for his consent or approval on the electronic contract using his email address and contact number as his electronic signature. Second, the method is reliable and appropriate for the purpose which the electronic documents was generated or communicated in all circumstances, including any relevant idea. Like, party A shall provide a reliable and appropriate email address and contact number. Like, for example, in a bank loan contract, he is to be bound into. Third, that it is necessary for the party sought to be bound in order to proceed further with the transaction to have executed or provided electronic signature. Like, for example, is getting a bank loan electronically. There is a need to provide an email address and contact number to properly proceed with that transaction. And lastly, the other party is authorized and enabled to verify the electronic signature and to make a decision to proceed with the transaction authenticated by the same.
So good day everyone, my name is Diane Hazel Ann A, Saguano, and for today I will be discussing the Section 9 of Legal Recognition of Electronic Data Messages and Electronic Documents. So before we start, let us know first about the electronic signature. So the big question here is, what is the electronic signature? So electronic signature or the e-signature refers to the data in electronic form, which it is logically associated with other data in electronic form and which is used by the signatory to sign. So this type of signature basically provides the same legal standing as a handwritten signature as long as it adheres to the requirements of the specific regulations under which it was created. So in the legal recognition of electronic data messages and electronic documents, Section 9 are the presumptions relating to the electronic signature. So in any proceedings involving an electronic signature, it shall be presumed that the electronic signature is the signature of the person to whom it correlates. Or simply say, it is the signature of the signatory person. It is also presumed that the electronic signature was affixed by the person with the intention of signing or approving the electronic data, unless the person relying on the electronically signed electronic documents knows or has notice of defects in or unreliably the signature or reliance on the electronic signature is not reasonable under the circumstances. So meaning, it was still presumed that the electronic signature attached in the electronic document was the signature of the signatory person, unless the person relying on the electronic document was given a notice that it has been defected and was not attached or affixed by the signatory person. So that would be all. Thank you and God bless.
Good day everyone, I'm Procedure Mansayon. I'll be the one to discuss the Section 10, Original Documents. Number 1, where the law requires information to be presented or written in its original form, that requirement is met by an electronic data message or electronic document if A. The integrity of the information from the time when it was first generated in its final form as an electronic data message or electronic document is shown by evidence eliande or otherwise. So what does eliande mean? Eliande mean it is from outside source where it cannot be derived from the document or the source itself. So for example, in case of an uncertainty in a document, in order to ascertain evidence, eliande will be received. Letter B, where it is required that information be presented, that the information is capable of being displayed to the person to whom it is to be presented. Number 2, paragraph 1 applies whether the requirement therein in the form of an obligation or whether the law simply provides consequences for the information not being presented or retained in its original form. Number 3, for the purposes of subparagraph A of paragraph 1, A, the criteria for assessing integrity shall be whether the information has remained complete and unaltered, apart from the addition of any endorsement and any change which arises in the normal course of communication, storage, and display. And B, the standard of reliability required shall be assessed in the light of the purpose for which the information was generated and in the light of all relevant circumstances. For example, A is a duly assigned external auditor and B a client which is under e-commerce industry. So A as an auditor has the option to audit around the computer, through the computer, or with the computer of B, and has the right to unrestricted data provided by B. But B as the one held responsible for the preparation of the statements. The given statements must possess and carry the actual occurred transactions without any malicious and questionable changes, together with its provided documents, and those encoded documents can be difficultly recovered, but there must be an outside source that can be easily provided for or gathered by A for those encoded documents for A to issue an opinion based on his professional judgment.